It's a pleasure to be here on a Saturday morning. I want to thank everyone who's taking time out to be here. I'm going to discuss the issue of Antic, the recent decision from the Supreme Court, but I'm going to approach it somewhat backwards. I want to start with some context. The concept of pretrial detention is an extraordinary thing. When you think about an accused person who's been charged with a criminal offense and to have them being held in custody prior to a determination of their guilt on the merits is indeed an extraordinary thing. As someone who has practiced criminal law from both sides, Crown and defense, and now sitting on the bench for 3 years, I am still remarked at the prospect of someone serving a sentence, effectively, for a crime that they did not commit, or that one that hasn't been proven beyond a reasonable doubt, and those two are equally the same. So where does that leave us? That leaves us with the issue of bail. Bail for many is the most important step in a criminal proceeding. For those of you who practice criminal law, you'll appreciate this comment, but for those who don't, let me explain what I mean. The bail provisions are found in Section 15 of the Criminal Code. Bail has a constitutional dimension, which means that the Charter of Rights and Freedoms provides that any person charged with a criminal offense has the right not to be denied bail with just cause. Just cause imposes a constitutional standard that must be met before the denial of bail can be valid. Now, bail was originally intended as a summary procedure that attempted to balance the presumption of innocence with ensuring that the accused person attended his or her trial. That was the original conceived notion of bail. Since then, it has morphed into something much larger. We are now seeing bail hearings that are really protracted. They are becoming mini trials. How and why did this happen? I would like to convey the message that for me, I see bail as a means of managing risk. Risk of three things. First, the risk that the accused person will not attend for his or her trial. This is referred to as the primary grounds. Two, the risk that the accused person will commit criminal offenses while on bail or interfere with the administration of justice, such as tampering with witnesses, for example. That's referred to as the secondary grounds. And third, the risk that the public will lose confidence in the administration of justice because of the nature of the charges that the person might be facing. This used to be invoked in the rarest and exceptional of circumstances until a few years ago in a case called Regina and St. Cloud, where some new life was breathed into the tertiary grounds for denying bail. I refer to this as the legal risk. So courts are faced with the legal risk when a person is confronted with a criminal offense. How does this square for the marginalized accused? The marginalized accused is he or herself at risk as well. They are at risk for succumbing to their difficulties, whether it's through poverty, whether it's through addiction, mental health. There are socioeconomic factors that have brought them to the steps of the courthouse. Marginalized people are by definition at risk. And when you look at it that way, the non-marginalized, who may not have the same challenges that the marginalized do, they might come from stable families. They might have people who are prepared and ready to supervise them. They might have the financial means to post bail. They might have the home and the stability of a home to return to every night to ensure that the legal risks can be mitigated. There is a collision of these risks happening in the bail courts every day. The legal risk with those who are at risk. So the question becomes, what can you, as advocates, and future advocates, and members of the public, do about it? And this is where the decision in Antic becomes important. In June of this year, 2017, the Supreme Court released a decision in Antic, which wasn't really anything new except affirming what we already knew, or criminal lawyers already knew, which is that in cases where the Crown Attorney, the prosecutor, bears the onus of proving why someone should be denied bail, the court must use what's called the ladder principle, which is to say that bail is only denied based on moving up the ladder in small increments. In other words, there's a presumption of release at the least onerous form of release, that being the person's own undertaking. And it is only at that point that you move up the step in the ladder to determine what form of release is appropriate. This has been in the criminal code for many years, but was not being used appropriately. That is what the Supreme Court of Canada said. Now, I feel a little embarrassed here because my good colleague, Justice Marginalized, who's going to be speaking to you next, YorkU, was one of the lawyers who argued the issue in Antic as amicus curiae, or a friend of the court. And I think he'd be in a much better position to tell you a lot more about Antic. But that's the message that you get from Antic, which is, look, an accused person who is presumed innocent starts with the presumption of innocence. You don't give up the constitutional safeguards. What is challenging about Antic is this. It applies to cases where the prosecutor bears the onus of proving detention. It does not apply to cases where the accused person starts with the onus, or a reverse onus. And that is where the collision becomes even more problematic. Because the marginalized person, the person who is at risk, often finds him or herself bearing the onus. So why does this matter? Well, bail matters because criminal justice participants will tell you that a person who is able to secure bail is able to properly defend themselves, to properly instruct counsel, to avail themselves of any rehabilitative steps if they are going to be pleading guilty, whereas the marginalized person who is at risk faces a larger prospect of being detained. That person cannot take all of those proactive steps to assist their position. So in this way, the concept of bail, in my view, becomes fundamentally important. So, what can you do as advocates? First, remind courts of the principles in Antic. Remind courts that there's a presumption of release where the prosecutor bears the onus. Remind courts that it would be an error in law to jump to a more restrictive form of release before you have exhausted the least onerous form of release. Justice Wagner in Antic makes it clear that the failure to do so is an error in law. Second, when you come to discuss the terms of release, advocate on behalf of the marginalized person who is at risk. Explain to the court that it is not the fact that they are at risk that matters in the bail hearing. It is the constitutional standard that must be upheld that is important. Do not sacrifice or trade off certain liberties for other liberties. For example, do not agree to terms just for the sake of releasing the accused. In bail courts, I often see this trade-off happening all the time. And for many reasons, I don't blame the at-risk or the marginalized person. They want their liberty. They are prepared to agree to a more onerous form of release, to more unreasonable conditions of bail, and more harsh terms of bail to secure the release. As advocates, it's your job to explain to the court why a term of release is reasonable, why it's necessary in the circumstances and consistent with the provisions of the criminal code. Unfortunately, at the stage of bail, the concern of getting released is placed at a higher premium at the expense of what that release is going to look like. Because if you're unable to craft a release that the marginalized person can actually abide by, you're running into potential problems where that person may breach their bail and find themselves in court, again having to prove why they should be released. So it becomes a vicious circle. That is all I want to say. I think my time is up. 10 minutes is not a very long time, but hopefully you've taken away a message here. I commend to you the decision in Antic. Paragraph 67 is perhaps the most important paragraph that you can read. It is a very well-written judgment and a very timely judgment. Because again, I repeat what I started with. Pretrial detention is extraordinary. Thank you very much.